I hope so, or I'm going to get
We
really
are.
confused.
No,
Okay.
we are. I think that's the intent of, and I assume the state is okay with that way as well.
I am Wesley Stone. I represent Jamie Paul Click, and in the Sevier County matter, I do reserve 3 minutes of time for rebuttal, please. So, in the Sevier County matter, in the first 2 counts, Mr. Click was charged with sale or delivery of heroin within 1,000 feet of a drug-free school zone. And the actual proof bore out that the quantity in that particular transaction was 0.05 grams, 5/100ths of a gram of heroin. And at that time, 3917-432 required a couple of things if a person was convicted of that. First, the judge had no discretion but was required to enhance the sentence classification, 1 classification higher, and the minimum sentence within the applicable range was required to be served at 100% and could not be reduced by sentence credits, which is what Judge Vance did in the Sevier County matter. But beyond that, he also imposed a sentence of 40 years. So at the time, Mr. Click was convicted of a Class B felony. He was a multiple offender, so it's range 2, and he was 25 to 40 years. So all that's correct. There's no dispute about any of that. But Judge Vance at sentencing imposed a 40-year sentence, which had the effect of requiring him to serve 25 years minimum on that, and then the remaining time would be with a release eligibility after 35%. And I recognize that the 2 20-year sentences in counts 4 and 5 and 6 and 7 are not before this court, but I think, and I've pointed out in the brief, that it's important in the context of justice that those 2 be considered by this court as well. Specifically, at resentencing, where Judge Gass had the opportunity to not increase Mr. Click's sentence from a Class B felony to a Class A felony, and not require Mr. Click to serve the minimum 25 years at 100%. Judge Gass concluded that it was not in the interest of justice to resentence Mr. Click. And in preparation for today, I took the liberty of trying to define justice. Doing this for 24 years, it's kind of a perhaps fluid thing for me. And I will report to the court that my research from reported cases in this court, the Court of Criminal Appeals, and the Tennessee Supreme Court results in one definition of justice. And there's some Latin in here, and I know it's about as much Latin as Augustus McCrae and Lonesome Dove, but Justice Neal, in the case of New York Life Insurance Company v. Nashville Trust Company, dealing with a constructive trust, in a concurring opinion wrote, "And what is justice? It was defined by Ulpian, spelled Ulpian, thanks to Google for the pronunciation, a great Roman legal author centuries ago, and he defined it as justice is the constant and perpetual will to allot to every man his due." So that didn't lead me anywhere, but it did lead me to my Black's Law Pocket edition from law school that I still have, copyrighted in 1996, and I was told today perhaps it's an ancient document, but it defines justice as the fair and proper administration of laws. We're before this court on what this court has treated, thankfully, a notice of appeal as a petition for writ of certiorari.
That kind of raises the issue that I have,
Yes.
or an issue that I'd like to discuss a little bit. Justice, as I have conceived it, is often context dependent, and what may be just in one case could be manifestly unjust, and in other cases it goes. So is the question here really, in the first instance, about whether justice warrants a resentencing, or under the standard for issuing a writ of certiorari, where I'm looking to see if the underlying decision is arbitrary, capricious, lacks any rational basis at all, am I really asking whether a reasonable person could conclude that justice doesn't warrant resentencing, even if I thought that it did, and that the failure to grant it would be wholly arbitrary? It strikes me that on the writ of certiorari, it's not just questioning whether justice in the first instance demands it, but whether it's wholly arbitrary not to grant resentencing. Would you agree with that?
If arbitrary and capricious meets the definition of plain and palpable abuse of discretion, perhaps. But as I understand how this court evaluates petitions for writs of certiorari, is that it has to determine whether or not there was a plain and palpable abuse of discretion.
I think typically as we talk about abuse of discretion, we're typically talking about someone who's operating outside of the ranges of reasonableness. So if we have a range here, and that each one of the decisions inside of this range from 0 to 1 are reasonable, someone picks something in there, then that's okay. If you're outside of that range, then it's not okay. I think that's really what we're talking about, right? Is that if you're outside of that range of reasonableness, it's arbitrary because it's not supported by reason, right?
I'm not prepared to speak to the arbitrariness, perhaps, of it. I've restricted my argument and kind of prepared my arguments for the abuse of discretion, but
it's still highly deferential, though. In other words, right? I mean, we're not making the issue, the determination of whether it's just in the first instance. We're reviewing whether someone else's determination is reasonable.
Well, and then that becomes a little more problematic for petitions of writ of certiorari. The court's is not permitted to review basically the correctness of the trial court. I mean, that's the standard as I set forth, I think, in my brief. But if I were to walk up to a justice or a judge on the street and simply say, I have a client who received 40 years for possessing for selling or delivering 0.05 of a gram of heroin, that doesn't sound a lot like justice. That's our argument. And when you add in the other 40 years that he has on top of that, Judge Vance ran these sentences wild. He basically ran them all consecutive to one another, so to figure out which one starts first and which one starts next and which one starts after that, I'm reminded of Judge Smith, a sessions judge out in Hickman County, and that's how he would tell people when they were receiving consecutive sentencing there, these sentences are running wild. That's what he would say. But as you go through that definition, because that's what's found in 3917-432, in the interest of justice. And so that's where I started this argument of this preparation, is because what is justice? 40 years with a minimum sentence of 25 at 100% for 0.05 grams of heroin, we submit to the court is not justice. It exceeds justice. It offends justice.
So in your example where you're on the street and you run into to Judge Smith on the street and you say, for 0.5 gram of heroin, my client got 40 years. What do you say, Judge? And my guess is the judge is probably going to say, that surprises me, but I'd like to know a few other things. One, I'd like to know what the law was. Does the law allow for a 40-year sentence? And to that, I think you would say it does. One element of justice is met, it's in compliance with the law. It's not itself arbitrary. Another thing the judge may ask you then is, well, what sets your client apart from other clients in similar situations? Did your client have an extensive criminal history, for example? And in which case you may say, he's got a little bit of criminal history here. And then Judge Smith may say, well, okay, I mean, if the law allows it, he's got an extensive criminal history, he was doing it in the school zone, where we know we have other issues there. The judge may conclude that, under the circumstances, 40 years is just. So I think maybe I wonder, getting back to it, the concept of justice is context dependent. And so what may be just for him, arguably, absolutely wouldn't be just for you.
And then in 2020, the General Assembly changed the law. And they reduced 1,000 feet, within 1,000 feet to 500, gave trial judges discretion, which Judge Vance did not have, Judge Gass did. And then they also created the presumption that required to serve the mandatory minimum sentence or the minimum sentence at 100%. And so when you add those facts into, you have to ask yourself, what was the General Assembly thinking? When I was before this court on direct appeal, as I recall correctly, it was Judge Easter, perhaps Judge Thomas, but I specifically
A motley crew indeed.
Motley Crew, indeed. You can say that. I'm not
I'm in trouble with my
amening.
colleagues.
I'm not
On the
amening.
record, I'm not saying that, yes.
But I remember at that time, we were really struggling with the fact that there were these long prison sentences by law, allowed by law, and the bias opinion had basically said the Court of Criminal Appeals really doesn't have a lot of discretion in sentencing, and I think that actually came up during that oral argument. But when you start factoring in all these things, then you start asking your question, okay, now justice as applied to the modification of 3917-432. Do we have an opportunity then to revisit this? And it's our position that yes, Mr. Click did have a criminal history, and he earned a range 2 classification on a Class A felony, as it was, if it was a Class B, which is what it started out at, it'd be what, 20 to 12 to 8 to 12, 12 to 20, it would be 12 to 20. So by his criminal history, he earned those heightened range classifications. But now that we have an opportunity to revisit it, Judge Gass, it's our opinion, abused his discretion in being able to re-sentence Mr. Click as it relates to that particular offense, and in the context of the additional 40 years that he had in those other two counts. So it's our position that at the evidentiary hearing, which we actually had in Sevier County, Mr. Click testified at that particular hearing. And one of the things I think that is important in that is that at that time, and as I understand it to today, is that he is eligible for his sentence end date, I think, is 2092, which is many, many years beyond what I think a 45-year-old person can serve. But, and I put this very discreetly in our brief, particularly as it relates to this particular case, that by giving Mr. Click what was then statutorily authorized, a sentence that exceeds a sentence one would receive for a premeditated murder or a felony first-degree murder, is something that does require, I think, an exercise of discretion in reviewing Mr. Click's sentence. But he was denied programs. His testimony was clear in that. He was denied programs while he was in the Tennessee Department of Corrections. They reserved programs for people who are going to see the streets sooner as opposed to later. By his sentence, he's not going to see the street. And by doing that, he lacked hope. And I think what he testified to was, I was living like I was never getting out. And then the 2020 amendment came out, and then the 2022 that allowed it to be retroactively applied. When he had an opportunity, while waiting in the Knox County Sheriff's jail, detention facility out in Maloneyville, he did take advantage of substance abuse classes, job readiness classes, family and community reunification classes, anger management classes, and behavioral change. So there is a glimmer of hope bore out by the 2020 amendment that now is retroactive based on the 2022 amendment. So it's our position that when you boil all this down, this court has to conclude whether the trial judge committed plain and palpable abuse of discretion when it reached an illogical conclusion that caused injustice to the complaining party, serving 25 years at 100% for distribution of 0.05 grams of heroin and a total sentence of 40 years, in addition to the cumulative sentence of 40 years he received for an effective 80-year sentence with a release date of 2092. A sentence greater than that required for first-degree murder. So it's our position that this court should grant this writ of certiorari and send this case back to the trial court for resentencing. If there's any other questions, I'd be happy to answer them, except as it relates to Latin.
Thank you.
Thanks, Judge.
May it please the court, Catherine Redding on behalf of the state. This court should dismiss the defendant's appeal. Because he has no right of appeal under Rule 3 or under the statutes, he is limited to a petition for writ of certiorari. But this remedy is only to be granted under unusual or extraordinary circumstances, and the circumstances here are not so extraordinary that they warrant this remedy. The trial court's order denying resentencing does not present one of the 4 very limited circumstances where this writ should be employed. The court conducted an evidentiary hearing on the petition. It considered the statutory factors for resentencing. It made findings that were consistent with the record and denied resentencing based on its conclusion that the new sentence would not be in the interest of justice, which is one of the statutory considerations. As a result, the trial court did not deny the defendant his day in court, didn't issue a decision beyond its authority, didn't issue a fundamentally illegal order because it was allowed to deny resentencing, nor did it plainly and palpably abuse its discretion. And if you look at the merits argument, because we understand from the case law that writs are not to be granted to kind of delve into the intrinsic correctness of a trial court's order. And the defendant's argument is simply that the court reached an illogical conclusion, erroneously assessed the evidence, and caused an injustice by denying resentencing. And those are really just regular abuse of discretion claims. So for these reasons, this court should not grant a writ of certiorari. But if it should decide to do so and consider the merits of the defendant's claim, it's the state's position that the record supports the trial court's conclusion that the interests of justice do not support a new sentence.
So this is an interesting and fast-developing area of law.
Yes.
What factors does this court generally look to decide? I mean, let me put it this way. In the position as a trial court judge, what do the cases from the Court of Criminal Appeals tell me as a trial court judge? What factors should I weigh when considering whether resentencing is in the interest of justice?
I think this court has directed trial courts to look at the statutory considerations,
Right.
which are whether the sentence would be lower, go into the presumption, and but the second, which is the second consideration, which is the one here, is whether a new sentence would be in the interest of justice. And part of that consideration can be looking at the defendant's criminal history and his record, his disciplinary record in TDOC. And I'll note that this court hasn't granted very many.
That's why I'm asking.
Sure.
Is this a good case and that we should identify factors that a trial court could consider when analyzing the interest, whether having satisfied the first part, now I'm looking to the second part, whether it's in the interest of justice to grant resentencing? What factors would you suggest? If you were writing an opinion, what factors would you suggest that we give guidance on?
I don't think that this is a good case because, as I mentioned, the defendant's argument is simply just one of the trial court abused its discretion. And it really has a lot to do with the decisions that were made by the original trial court. So the original trial court was the one that imposed an 80-year sentence. It was the one that imposed a 40-year sentence. And what this court, at the petition for resentencing hearing, was considering, the focus of its decision was on the defendant's prior criminal record and on the defendant's disciplinary record. And those, I believe it's set out by statute that those are some things that courts are supposed to consider. So,
As we were talking here, though, the justice is often context dependent. So in the context of resentencing generally, can you think of other factors trial courts should be looking at? And if we're having trouble identifying those, does that say something about the nature of the inquiry?
I think that trial courts should be directed, and I think that they are already directed to consider the original the original offense, consider the original sentence, consider why the original sentence was imposed, whether it was compliant with the law, whether it was reasonable under the law, and then look at what the defendant has done since the sentence has been imposed. And that gets to how he has behaved, how they have behaved, what they have done, what efforts that they have made, and during their incarceration. And obviously, I take defendant's point that given his release date, he hasn't been permitted to do a lot of things. But I think if you look, and this is really why I think that the record supports the trial court's denial of resentencing. I mean, the defendant clearly has an extensive criminal history. He has 7 prior aggravated burglary convictions, 3 priors for theft, over 1,000, and 1 prior each for conspiracy to possess with intent to sell over 150 grams of heroin in drug-free zone, aggravated assault, and sale of oxycodone. And obviously those all occurred before he was convicted here because he didn't get released, so he couldn't be out in the world committing these offenses. But if you look at his incarceration in TDOC, my recollection is that he has 30 disciplinary infractions, the vast majority of which occurred after he was sent to prison in this particular case. And those infractions are not minor. There are 6 counts of possession of a deadly weapon, including one after, I believe it was in March 2022. He was convicted of possession of a 9-inch knife. So that is after the amendments, or at least, I don't remember if they went into effect on July 1, but very close in time to the amendments, and certainly after the 2020 amendments. So 6 counts of possession of a deadly weapon, 5 counts of tampering with security equipment, 5 counts of possession of an intoxicant, and 5 counts of defiance, 5 counts of failure to report as scheduled, and 2 counts of contraband. And there was testimony at the hearing that the defendant possessed and overdosed on fentanyl in January 2023 while in custody. So this is a case where the record, it is reviewed for abuse of discretion. If this court gets to the merits, it reviews the trial court's decision on whether to grant a new sentence for abuse of discretion, and the court is allowed to consider prior criminal record and disciplinary history in prison. And this is one where we do not have a defendant who is a good candidate, whose record supports, and in this particular case, as justice is applied to this particular defendant, this is not somebody who, the record supports the court's conclusion that a new sentence would not be in the interest of justice. If there are no further questions.
Have there been any cases out of our court yet that have dealt with this where it's been considered for purposes of the writ of certiorari? Or have they all been appeals and our court has said, sorry, but you don't have a right under the rules to appeal denial of modification of sentence?
My recollection is there was a case out of the middle, and I know the defendant's name, but it is escaping me.
Judge Holloway had one, didn't he?
Did I miss it?
And I believe
they
Judge Easter was on
Judge
that
Easter,
panel
yes,
as well, where the court granted the petition for writ of cert before argument. So then at argument, the Eric Patton, there it is, the Patton case. So at argument, the only question left to resolve was whether the trial court abused its discretion. And I believe the court found that it did, the trial court did not. And then there was one out of the East, and I believe it was Watson. But that was a situation where the court did not conduct a hearing because it misread the statute as it related to clemency. So it found that because that defendant had applied for clemency, and so the court concluded based on the clemency decision that he was not entitled to a hearing. So this court said no, and I believe that came up as a petition for it had to have, and this court sent it back down for a hearing. So that is my recollection that there have been 2. So if there are no further questions, the state asks this court to dismiss the appeal or alternatively affirm the judgment.
yes, this court should develop a test involving factors to determine how a trial court should exercise its discretion in these kinds of cases.
What would you suggest?
Well, some of which I've argued, and that is the overall effective sentence, how it fits into everything else. I think that's extremely important. I think that another one would be related to Mr. Click's testimony that prior to not being a drug addict, his brother was alive. His brother passed away. He became a drug addict. This court has to be aware of co-occurring mental health and substance abuse treatment. Mr. Click testified he had never received drug treatment. I think that equally applies to mental health treatment, and I think those are factors that a trial court should exercise when reviewing one of these resentencing questions. In addition to what the state has already pointed out, and I will admit that Mr. Click's criminal history is not good. I can't ignore that. But that's already a factor. That's already what the trial court is required to consider. And I picked up on perhaps something the state had said, that Mr. Click is not a good candidate for resentencing. Well, how do we define good? Well, then we have to go back to what is justice. How do we define what is a good candidate? And it's our position that he may not be the best candidate, but he is a candidate that's worthy of consideration. And I will address Judge Montgomery's question about one of the cases, and I believe it's the Parker case, and I think it's the one that Ms. Reddings was speaking of, and that is the case where, because I did speak with Ms. Butler, the lawyer who handled that case for Parker, I don't know if it was a Mr. or Mrs., but in that case, the trial court had considered a gubernatorial, perhaps a partial consideration of clemency or something of that nature. But be that as it may, it's our position that this court should develop that. I would not remiss an opportunity to say I just hope the court weighs those factors in our favor. But it is, there's not a lot of case law out there. There's just not. And I think this is a good opportunity to develop that in this case. So we would ask this court to send it back to the trial court, grant the writ. Thank you.
Okay, now, do y'all need a moment, or are you ready to proceed on the next one?
I'm ready.
Or you want to call it the next case then, please?
State of Tennessee versus Jamie Paul Click.
This is the Knox County case.
Yes, Your Honor.